Hello everyone, welcome to day 29 of Polity Daily Drill. Let's begin. First question. With reference to the District Planning Committee, DPC, consider the following statements. First one, the 74th Amendment Act provides for the establishment of DPC. Now DPC, of course, is a constitutional body under Article 243 capital Z D. Just like one more body, MPC, the Metropolitan Planning Committee under Article 243 ZE, and yes, these bodies have been formed or established under the 74th Amendment Act. So statement 1 is correct. Now, 4/5 members of the DPC are nominated by the governor. Now, this is actually wrong. In fact, it's the exact opposite. 4/5 members of DPC are elected by and from amongst the elected members of the panchayat at the district level and of course members of the municipalities in the district. And remaining 1/5 are the nominated ones. So 2 is wrong. And the third one, it has representation from both rural and urban population of the district. Yes, absolutely correct. Why? Because its membership comprises of members of panchayat as well as members of municipalities. The rural representation as well as the urban representation. So 3 is also correct. 1 and 3 are right. How many statements are incorrect? So how many are incorrect? Only 1. A is the right answer. Moving on to question number 2. In the context of Indian polity, the need for separation of power is best reflected in which of the following options? So number 1, to ensure the supremacy of the legislature, for decentralization of power, to maintain the independence of the judiciary. Yes, this is the answer. Independence of judiciary. What does it mean? The freedom to make decisions based on laws and facts without any interference or influence of either the legislature or the executive. So C is the right answer. Moving on to question number 3. Consider the following statements regarding amendments to DPSP in the Indian Constitution. The 42nd Amendment Act of 1976 is notable for adding Article 39 capital A to the DPSP, which directs the state to promote equal justice and free legal aid. Yes, absolutely correct. In fact, to fulfill the obligations under 39A, we have an entire structure of NALSA, SALSA, DALSA and TLSCs across the country. So 1 is correct. Second one, the 44th Amendment Act of 1978 introduced Article 48A, which obliges the state to protect and improve the environment and to safeguard the forests and wildlife of the country. Now see, the article and the meaning is actually correct. But sadly, this article was added through the 42nd Amendment Act and not the 44th Amendment Act. So 2 is wrong. Third one, the 86th Amendment Act 2002 added Article 45 under the DPSP, which mandates the state to provide ECCE, Early Childhood Care and Education, for all children until they complete the age of 6 years. Now, on the face of it, it might seem to be correct because yes, Article 45 does provide for all these things. However, the 86th Amendment Act did not add but only modified, amended Article 45. Why? Because we already had an Article 45 which said that the state should endeavor to provide education to all the kids between 6 to 14 years. This was made into a fundamental right 21 capital A and modification was made to Article 45. The subject matter, the content was changed. It was not added. So 3 is also wrong, and hence how many statements is or are correct? Only one statement is correct. Moving on to question number 4. Consider the following statements. Statement 1. Any arbitrary action by the government limiting fundamental rights can be challenged in the Supreme Court for violation of the Constitution. Yes, Article 32, which Dr. Ambedkar has called the heart and the soul of the Constitution, of course, allows for the Supreme Court to issue orders, directives, or writs. So, 1 is correct. Statement 2. The Constitution of India is the outcome of rights of individuals. No, this is wrong. In fact, the Indian Constitution is the source of the rights, not the outcome of rights. Okay? The rights are the outcome of the Constitution. So 2 is wrong. And hence, statement 2 is incorrect, which means C is the right answer. And the last question for today. In which of the following situations would the imposition of President's rule under Article 356 be improper? So number 1, maladministration in a state, allegations of corruption against the Chief Minister, if the state government works against secularism, or disregarding a constitutional direction of center by a state. Now Article 356 and its imposition being improper has been subjected to a very famous judgment, and that is the S.R. Bommai case of 1994, in which Supreme Court said that there are only very few, limited, and just 3 instances of the rightful proper imposition of President's rule. Number 1, if the state government works against secularism. Number 2, on grounds of Article 365, which is what? If the center gives a binding direction to states and the states don't follow it, then it can be seen as a proper way to, or a proper situation to implement President's rule, which is the 4th statement here. And also if there is no possibility to form the government in case of hung legislature, hung assembly, and if the governor has utilized, exhausted all possibilities of forming the government, then we can go for President's rule. In all other cases, the imposition would be seen as improper. So whether it is maladministration, improper, whether there is an allegation of corruption against the Chief Minister, improper. So the right answer here is going to be 1 and 2A. The improper situation to impose the President's rule, 1 and 2 only. That's it for today. Let's meet tomorrow. Till then, that is all for me. Jai Hind.